Good morning. I am Akmal Azad, Director, Bangladesh International Arbitration Centre, BIAC. Mr. Chairman of NIAC, Dr. Mukti Rizal. Mr. Muhammad Rumi Ali, CEO of BIAC. Mr. Matrika Prasad Niraula, today's moderator. Distinguished panelists. It is our privilege to host today's webinar jointly with Nepal International ADR Center-NIAC. At the outset, I would request our CEO, Mr. Muhammad Rumi Ali, to deliver his welcome address. Mr. Ali is the Chief Executive Officer of Bangladesh International Arbitration Centre, BIAC, since October 2015. A former Deputy Governor of Bangladesh Bank, the Central Bank of Bangladesh, Mr. Ali started his career with ANZ Greenless Bank in Bangladesh in 1975 after completing Masters in Economics from the University of Dhaka. During his career with ANZ Greenless Bank, Mr. Ali worked in India, UK, and Australia. In 1997, he was appointed as the CEO of the bank's operation in Bangladesh. Mr. Ali was chairman of BRAC Bank, founder chairman of Bikash, the first mobile financial service in Bangladesh, and CEO of Standard Chartered Bank Bangladesh. He also served as the managing director, Enterprises and Investments of BRAC. Currently, Mr. Rumi Ali is the chairman of AB Bank Limited. Over to sir.
Thank you, Mr. Azad. Chairperson of Nepal International Arbitration Centre-NIAC, Dr. Mukti Rizal, Justice Srikanta Paudel, Honorable Judge, High Court of Nepal, Barrister Farzana Ahmed, Advocate, Supreme Court of Bangladesh, and Senior Vice President and Head of Legal of Dhaka Bank Limited, Dr. Kumar Sharma Acharya, Senior Advocate, Mediation Expert, Nepal, Barrister Khandakar M.S. Kausar, Advocate, Supreme Court, Bangladesh, and Regional Representative of South Asian Chapter, ICC Young Arbitrators Forum, Ms. Prakriti Yonzon, PhD scholar, lawyer, and ADR practitioner, Nepal. Mr. Shahryar Sadat, Director, Academic and Legal Empowerment Center for Peace and Justice, BRAC University, Dhaka. And today's moderator, Mr. Matrika Niraula, Managing Director of NIAC. Our distinguished audience who've joined us on Facebook, LinkedIn pages, and on Zoom platform. Assalamu alaikum, namaskar, good morning, and welcome to you all to BIAC's 17th webinar on commercial dispute resolution through mediation, jointly organized with Nepal International ADR Center. It is now globally held that alternative dispute resolution is an effective and efficient process, particularly for commercial parties worldwide, to further develop ADR. Bangladesh International Arbitration Centre, the only state-licensed ADR center in Bangladesh, is working relentlessly for the last 10 years. We are delighted that today we are being joined by Nepal International ADR Center-NIAC, who, like us, is committed to accessible and credible dispute resolution service through arbitration and mediation in Nepal. For this, I'd like to thank the chairman of NIAC and warmly welcome our participants from Nepal. I'm delighted that Justice Srikanta Paudel, Honorable Judge, High Court of Nepal, will be speaking today. I'm sure his participation will bring, as they say, the view from the bench, which is no doubt very important, particularly to our distinguished speakers and also to the audience. Distinguished audience, ladies and gentlemen, it is a happy coincidence that just 10 days back, on 24th of November this year, there was an announcement made from UN General Assembly, which said, the UN General Assembly on Wednesday affirmed the graduation of Bangladesh, Laos, and Nepal from the least developed country LDC category In a resolution, the General Assembly also decided to provide the three countries on an exceptional basis with a 5-year preparatory period leading to graduation, as countries would need to prepare for the graduation while planning for a post-COVID-19 recovery and implementing policies and strategies to reverse the economic and social damage incurred by the pandemic. The standard preparatory period is 3 years. These three countries were invited to prepare during this 5-year period their national smooth transition strategy with the support of UN system in cooperation with their bilateral, regional, and multilateral development trading partners. I'd like to also draw your attention to the fact that both our countries have been experiencing robust growth trends. Bangladesh at 7.7% and Nepal at 6.3% last year, with a 5-year average of 7.1% and 4.8% respectively. It is precisely this growth that brings in new challenges for economies going forward. The UN General Assembly has therefore granted both these countries a 5-year period in which to prepare our economies for the incoming changes. One of the most visible parameters that always accompanies such growth is the increase in both national and international trade volumes. This means a quantum increase in number of contracts and agreements between parties with multiplicity of jurisdictions, laws, and therefore complexities. One of the unwanted but inevitable outcome of such a scenario is increase in disputes between parties. This situation calls for a more robust and suitable dispute resolution infrastructure, and we will need a policy response that puts in place laws, guidelines, processes, and institutions. It will also critically require human resources trained and practiced in effectively and efficiently manage these challenges. While there are judicial processes, but globally the trend has been to move away from the more formal process of judicial to alternative dispute resolution through arbitration and nowadays increasingly through mediation. Thus, a capacity enhancement in ADR is also needed. The benefits of these ADR processes are not lost on the private sector players in the developed world, but do we have the effective capacity to handle the future complex needs of our economy? I personally believe we have a long way to go, and I also submit that time for action is now. It is therefore an opportune time for Nepal and Bangladesh, who are neighboring countries and founding members of South Asian Association for Regional Cooperation, SAARC, to work together. We have good business relationship both on the nation-to-nation and citizen-to-citizen level. Considering the mutual interests and shared goodwill, BIAC and NIAC, both these institutions, can in their own limited ways work towards complementing our national effort. It is in this backdrop that BIAC and NIAC have come together to host this webinar. This is just a stepping stone to start the process of cooperation between two institutions to assist each other to create an ADR landscape that can face the upcoming challenges. It is important to note that an institutional framework for ADR can effectively provide the total spectrum of facilities and services that business communities will need as global trade volumes between countries increases. I will not dwell on the academic or practical issues of today's webinar, as we have far more distinguished speakers than me on the matter, and you are no doubt waiting to hear from them. I would, however, just once again emphasize the need to upgrade our ADR infrastructure so that our business communities do not have to seek these services offshore at a significant increased cost and other disadvantages. With these words and thanking the learned participants and our moderator, Mr. Matrika Niraula, and hoping that you all have a useful and constructive discussion, I end here wishing our distinguished audience, my colleagues in NIAC and BIAC, and in particular, the chairman of NIAC, Dr. Mukti Rijal, a very happy 2022. Thank you all.
Thank you, sir, for your insight. Now I would request our esteemed moderator to take the floor. Mr. Matrika Prasad Niraula is the Managing Director and founding and life member of Nepal International ADR Center-NIAC. He is an arbitrator, mediator, and also a senior advocate and corporate and property law consultant. He is a life member of Nepal Mediator Society, NEMS, Nepal Council of Arbitrators, NEPCA, and Management Association of Nepal, MAM. Mr. Niraula is a board member of the Asia Pacific Center for Arbitration and Mediation, UPCAM. Over to Mr. Niraula.
Thank you so much. Am I audible?
Yes.
Thank you so much, Mr. Haddad. Yes, I'm going to take my responsibility. First of all, I want to introduce my friend, Mr. Azad. Mr. Azad is the director of BIAC. He is the additional secretary of Ministry of Agriculture of Government of Bangladesh. Before joining administration, he has worked for civil judiciary. Mr. Azad studied law and public administration in University of Dhaka and University of Manchester, UK. He was trained on local level governance in India and legislative drafting in Canada. Thank you so much for introducing me and also for pivotal role you have played in this event, Mr. Azad. First of all, I would like to offer my sincere thanks to the CEO and chairman of BIAC and entire team of the BIAC for this collaborative event, and special thanks for giving me this role of moderator. However, you may know that our official language is Nepali, not English as in Bangladesh, even though I will try to go ahead as a moderator with your kind cooperation. Indeed, I have no proper words to offer my sincere gratitudes for this trust. As a working tools of NIAC, I hope to work for innovative partnership between BIAC and NIAC, which should go a long way. I am seeing so many commonalities with BIAC and NIAC, which energize for qualitative collaboration in the days to come. This time, we have chosen this theme on mediation as commercial dispute resolution through mediation, because mediation is practiced well in both the countries. We have requested Nepali speaker to touch 3 different areas: banking disputes, investment disputes, and Singapore Convention and Mediation. However, I could not send my request to a speaker from Bangladesh, but I know they are well prepared and they are ready to go ahead. I would like to welcome all speakers and BIAC and NIAC families and all participants. So Without much delay, I want to start my duty with a beautiful quotation by Wallace Stephen. He says, after the final no, there comes a yes, and on that yes, the future of the world depends. Indeed, mediation is the process of seeking the final yes. With this word, I would like to go ahead with your kind permission. First of all, I would like to call upon Justice Srikant Paudel. I would like to say few words about Justice Paudel. He is Honorable Judge of High Court of Nepal. He has been working with Nepali judiciary for over 3 decades. He has LLM degree in commercial law and master degree in political science from Tribhuvan University. He has published so many articles in different topics of mediation. With these words, I would like to request Justice Paudel, please go ahead, sir.
Thank you, Senior Advocate Matrika ji. Respected Chair, distinguished guests, members of the BIAC and NIAC, and ladies and gentlemen, it is my greater pleasure to talk in this great conference on the issue of importance of banking dispute resolution through mediation. As we all know that effective dispute resolution is the foundation of economic growth. So I will talk little about importance of banking disputes resolution through mediation.
Mr. Srikant Paudel would like to show you a presentation. So if you be so kind to enable screen sharing for participants.
Suman, you can share.
Screen sharing.
You can share your screen, please.
Okay.
If possible, please. Yeah.
Okay. Good morning, everyone. And it is my great pleasure to talk about some words on the importance of banking dispute resolution through mediation. This is my outline of presentation. I will talk little about nature of banking dispute and appropriate cases for mediation. Why mediation for banking dispute? Nepal's perspective, and Mediation Act and other legislations. What are the challenges for mediation and way forward? This is simple outline. Yes, it is when the society advances, there is the high possibility of highest degree of level of dispute it suffers. So, effective dispute settlement mechanism is the cornerstone of the development of the economy. And ADR offers lowest cost, faster resolution, greater informality and flexibility, as all we know, greater confidentiality, more control over the process of parties, and greater chance of preserving harmonious relations to the future. As all we know, arbitration is the first and oldest form of ADR and is well recognized mode of commercial dispute settlement. Nowadays, mediation is deemed to be one of the fastest growing forms of dispute resolution in the world, in the commercial sector also. Interest in mediation is increasing worldwide. Modern commercial ADR is growing in worldwide. As I know, ADR is growing in integration with court or litigation system in latest time. And online ADR resolution is opening up as a new area of activity with the continued growth of online commerce. I will talk about what may be the nature of cases appropriate for banking dispute. These are some nature of cases which may be arise in the banking disputes. These may be capital relating to capital of banks, ratio of ownership, change of ownership, merger and restructuring, liquidations, sale or placement of bonds, customer deposit, credit, collateral-based lending, agreement between debtor and creditor. Similarly, incorporation, operation, management, regulation of banks, it is managerial issues. Similarly, relations between management and employees, employee job related issues, conflict among board members, management stakeholders and other stakeholders, shareholders, division of power and responsibility of board of directors, commercial transactions of bank, promissory note, foreign exchange, bank guarantee, LC, other intra-bank transactions. Similarly, bill of exchange, check bouncing, unauthorized ATM withdrawals and other issues. Similarly, bank contract, these are some example of banking contracts. Similarly, banking finance, financing contract, claim over faulty goods or other services, copyright or IP issue and technology transfer. I think these are the some issues or conflict which may be arise in banking areas. And I think mediation may be appropriate for all these issues. Now, why mediation is appropriate for commercial dispute? As we all know, mediation is the best dispute resolution system in the latest days due to the crisis of competence, efficiency and impartiality of judiciary in business related matters. Most of the business prefer out of court settlement for their disputes and they go to courts only when all avenues are out of court settlements or closed. Judges may lack knowledge about complex technology, business usage, practice, complicated business arrangement and growing volume of transitional business transaction. Similarly, business community has no interest, time to battle for litigation. So ADR can contribute improving corporate governance practice, strengthening investor confidence, supporting business community, reducing cost of dispute and maintaining relation between parties of the dispute. So mediation are innovative fact in the life of banks. Similarly, other life mediation may appropriate. Similarly, mediation may be appropriate for banking life issues or conflict. Mediation is affordable. It is flexible and easy tailored way of solving dispute. It helps for settling dispute in a low cost, as we all know, in quicker, safer and smoother ways. And it is amicable and friendly settlement of dispute. It is a means. It may play a role in re-establishing the mutual trust and repair damaged relationship among the parties of the cases. It is new notion of access to justice. It can promote access to justice. It is useful for cross-border disputes. Similarly, mediation is a management tool for good corporate governance. In latest days, it has been developed as a management tool. So, as we all know, mediation may be appropriate for the settlement of dispute in lower cost, faster resolution. As we all know, I am not going to talk about more. Now I am going to Nepal's perspective on mediation and banking dispute. The use of mediation to resolve dispute is not new phenomena. Use of mediation is not new phenomena in Nepalese society like Bangladesh. It has long practice in Nepal, though it is not purely modern mediation. There are some hybrid practice. Modern mediation tradition has been started since 2000 in Nepal. The Nepalese constitution also has focused states on the ADR. Judicial mediation had got legal validity since 2002 in Nepal. Mediation is gradually finding place in the legal framework of the country. Now, mediation consists of lawyer and non-lawyer mediators. Commercial mediation is not widely used in Nepal. It is, I think, it is infancy. It has to grow. We are thinking commercial mediation has been inserted in various legislation. I am going to talk about it later. Among them, Mediation Act, it is the first comprehensive umbrella legislation on mediation in Nepal. It covers commercial, judicial, and community mediation. It is the mediation legislation which deals with the mediation procedure. It opens several paths to the mediation. Mediation through contract, pre-litigation mediation, before the case is instituted on the court. Judicial mediation, it means on the request of parties, if the case is pending in the court, any party can request bench or court for the mediation, or by the initiation of the court, cases can be referred for mediation. So these are the paths for referral of court pending cases in mediation. However, there is no mandatory mediation under the Act, but mediation should be pursued where the parties have expressed interest of mediation through the conduct. If parties have explicitly insert the mediation provision on contract, they have to pursue for mediation. This Act, Mediation Act, has constituted Mediation Council as a regulatory body, which consists is a business committee also. Other legislation for mediation are mainly the Bank and Financial Institution Act 2017. Its section 123 is appropriate for mediation and other ADR processes. It clearly spells out any dispute between banks or financial institutions shall be settled in mutual consent. Where a dispute could not be settled through mutual consent, the Rashtra Bank, it means the central bank, shall settle the dispute through mediation or other methods of disputation under the prevailing laws. Similarly, the Debt Recovery Act, similarly the Arbitration Act, though it mainly focuses on arbitration, however, the section 40 deals with are made if the parties feels which case is in the process of arbitration, it can be settled through mediation. So our Arbitration Act has made provision for made. Similarly, Labor Act and Local Self-Government Operation Act has also made our prohibition. This is a hybrid provision in this legislation. Similarly, civil code and civil procedure code like Bangladesh, there is some provision of mediation in section 13 and section 194, with principle of civil procedure focus on mediation. First, focus on mediation and then litigation. Similarly, FITA, Foreign Investment and Technology Transfer Act, Privatization Act, mediation and rules and court rules, these rules also focus on mediation. Similarly, so I will likely slightly touch on what are the related legislation on mediation in our two neighboring country, Nepal and Bangladesh. I have enumerated some list of Nepal, as I already mentioned. Similarly, as I found, the Salya and Mimamsa system is a long practice system in Bangladesh. Similarly, other legislation, Code of Civil Procedure, Authoring, Adalat, Money Loan Act, Codes, Arbitration Act, Bankruptcy Act, Family Court Ordinance, Bangladesh Labor Act, Gram Adat Act, Settlement of Dispute Board Act. These are some legislation which deals with commercial mediation too. As I discuss, as I talk, there are some challenges in mediation in Nepal. I think these challenges are also prevail in Bangladesh, because mediation is in infancy in other field and it is so infancy in the commercial field. So it has so many challenges. Among them, first one is the absence of informed understanding and knowledge of mediation of academic, legal, and business communities who can be benefited, they are not know about mediation and other bank management. Similarly, absence of mandatory mediation in certain nature of commercial cases. I already mentioned there is no provision of mandatory mediation in commercial cases. Similarly, there is no attraction for mediators and parties of cases to settle their case through mediation. Lack of adequate infrastructure for the promotion of mediation in Nepal. Similarly, I think this problem may have in Bangladesh too. Similarly, this may be mediation center, mediator manuals, and other infrastructure have lacked. Similarly, no proactive role of judges for referring commercial cases for mediation. Similarly, no use of mediation clauses on contract. When we framing contract, we have no practice of using or inserting mediation clause in the contract. Absence of specialized, skilled, dedicated, high professional, qualified, and sufficient commercial mediators. This is other challenges in Nepal. Similarly, absence of specialized training on banking disputes for mediators and education in mediation. There is no higher education in mediation in Nepal. Role of mediation council for the promotion of commercial mediation is not sufficient. Though mediation council is taking some effort, though it is not sufficient. Weak, complicated compliance monitoring of code of conduct of mediators, it is so weak. Similarly, absence of coordination and research activities among banking institutions, mediation institutions, and mediation councils, court, and training forums. So, I have spelled out some challenges. Now, I have proposed some suggestions for the overcome of these issues. Similarly, I have talked about prepare specialized, dedicated, or high professional and qualified commercial mediators, because mediators are the backbone of the mediation system. If mediator become competent, qualified, the mediation will succeed more. Similarly, develop mediation as a separate profession. Establish mediation center in core banking and commercial area. It is core necessary in Nepal. Similarly, I think it is necessary in Bangladesh. There is same issues in Bangladesh. Use other ODR and online mediation and modern tools of mediation, which save parties time and money. So it is necessary to use modern tools, technologies for dispute settlement through mediation. Similarly, provide motivation for parties of dispute to use mediation. Similarly, I found section 12A of the Commercial Courts, Commercial Division and Commercial Appellate Division of High Court of India, 2008. It is lately found. The Act has made provision that mandatory pre-institution mediation for banking dispute except banking offence. There is provision. I think this provision may be appropriate for Nepal and Bangladesh too. Prepare secret mediation guideline or manual for banking dispute. It may be our other appropriate tools. Similarly, strict execution and follow-up codes of conduct. Insert mediation or other ADR mechanism clauses on commercial contract. As I mentioned, if we insert commercial ADR provision on commercial contract, the party will follow ADR and mediation. And other tools, maybe I suggest use mediation first principle before instituting the case in the court or court pending cases. In both areas, first we have to make effort for mediation, and if mediation fail, then we have to proceed for litigation. So mediation first principle is may be appropriate. Similarly, bank management have to take initiation for the use of mediation as a management tool for conflict prevention, not only for conflict resolution. Bank management have to take mediation as a tools for conflict prevention. Similarly, mediation should be allowed by the following legislation. Like check bouncing cases, there are many check bouncing cases in commercial benches. So the Banking Offence Act and Debt Recovery Act have made provision for mediation for such cases, though present legislation do not clearly expelled about mediation. As I read, there are many check bouncing cases in India in the local law which are settled through mediation. So this experience may be appropriate for us also. Similarly, other promotional measures also need for the promotion of mediation in Nepal and Bangladesh. So for the promotion, like FNCCI mediation service providers like NIAC, Nepal Mediation Society, these institutions have to play vital role. They can assist for the promotion of mediation. So we have to motivate such institutions. So this is my last word, that there are some legislation for commercial mediation in Nepal, though it is in infancy in Nepal. There is no proper initiative and practice of using mediation for settling banking conflict and disputes. Business and banking communities, mediation council, and institutions involved in mediation have to work together for effective use of mediation for settling commercial and banking conflict or disputes. Thank you for giving me this vital chance for organizers. Thank you.
Thank you so much. Thank you so much, Srikant Shriman, for your wide and insightful presentation. Thank you so much. Next, I would like to request Barrister Farzana Ahmad. I would like to introduce her with few words. She is a Senior Vice President and Head of Legal Affairs Division of Dhaka Bank Limited. She graduated in law from the University of Dhaka and also from University of Wolverhampton, UK. She is a barrister at law from the Honourable Society of Lincoln Inn, England and Wales. She is also an advocate of Supreme Court of Bangladesh and accredited mediators of ADR and ODR International, UK. With this word, I would like to call upon Barrister Farzana, please.
Please open your mic.
Thank you, Mr. Metrika Nirvana. Assalamu alaikum and good morning to all present participants of today and viewers. I would like to thank BIAC and NIAC for inviting me as one of the panelists of today. Today's topic is resolution of commercial disputes through mediation. Mediation is one of the ways of alternative dispute resolution, and as today's topic is commercial dispute resolutions through mediation, I would like to concentrate on mediation only, and from the Bangladesh perspective. In Bangladesh, the concept of mediation is becoming popular gradually. I would say we have got two types of mediation in Bangladesh. First one is mediation in judicial process, which is already is a popular concept. And second one is private mediation before judicial process or arbitration process. So mediation in judicial process is a mediation where litigation is ongoing and litigants would like to mediate their issues through mediation and in presence of a neutral third-party skilled mediator. Once two parties reach their understanding of in a common point, then the parties do write their resolution into a written contract, and the contract normally is submitted before the relevant court, and then the relevant court passes a decree on their settlement agreement. We call it Solenama or Sole decree in Bangladesh and compromise decree in English. So this type of mediation, which is annexed to judicial process, is ongoing in Bangladesh, I would say, to a good extent. We have got another kind of mediation. Basically, I would say this is a concept we are trying to introduce in Bangladesh to resolve civil and commercial disputes quicker. That is private mediation. The mediation, this is a mediation where two parties do sit together voluntarily and in the presence of a neutral skilled mediator. The techniques used in this kind of mediation is also the same as the techniques used in mediation in judicial process. I already said that the mediations during litigation or judicial process is already a popular concept in Bangladesh because of the factor that once the parties do reach a contract between them in a mediation through litigation process, then the relevant court passes a decree on their agreement. And if one of the parties later on denies to obey that decree or settlement contract, then the innocent party will have right to enforce that mediation award or settlement agreement or resolution through mediation or the decree. And this is the main factor which is making a mediation in judicial process popular amongst the people in Bangladesh. But we do have problem with enforcing resolutions in mediations which are the results of private mediations. And this is the main problem, or I would say this is the main challenge in Bangladesh, for which people are less tend to use private mediations as their dispute resolutions mechanism. As I'm from the banking sector and I'm a legal professional, as I'm from the banking sector and I'm a legal professional too, I saw many banking disputes over court throughout my whole career. I personally appeared before many authoring courts and high courts for banking matters, and now I'm serving as one of the leading private commercial bank of Bangladesh as head of legal affairs division. And now I'm facing, or I would say banking sector or the financial institutions are facing to recover their outstanding from non-performing loans. The major reasons for less recovery from the non-performing loan in Bangladesh is because our judiciary is overburdened with the huge number of pending cases before each and every level of courts of Bangladesh. So normally when a party or a bank file a case for recovery of loan, it takes at least 2 to 3 years. If it is a big loan, sometimes it takes 3 to 10 years even. I have seen the cases which prolonged beyond 10 years even. That is why as a stakeholder from banking sector, I would like to express my desire that if the banking sector can use mediations, I mean private mediations, which held before the litigation stages or arbitration stages as frequent as we can, then the recovery of non-performing loans would be much more better. In my opinion, if it is not possible to mediate each and every loan disputes, but my recommendation is that at least we should resolve retail and SME loans disputes through mediation. If we can resolve our retail and SME loans disputes through mediation before taking any formal process in court or arbitration, then I would say our recovery from non-performing loans would be much more higher. That's for sure. So our and we would like to recover non-performing loans by the using the techniques of mediation, but we are facing problems with regard to the enforceability of mediation award by the courts later on if one of the parties does not obey that mediation resolution. So in Bangladesh, in my opinion, we need complete law on mediation, on private mediation actually, or incorporating some appropriate mediations related provisions in our existing Offering Adalat Ain, which is our recovery act from non-performing the loans. So if we can incorporate appropriate provisions in our existing Authorin Adalat Ain, then I would say our banking sector or financial institutions would be benefited to a greater extent. That's for sure. I would like to invite our Parliament to enact appropriate law on mediation or incorporate provisions in relation to private mediations in our existing legal system, say for Authorin Adalat Ain 2003 and the CPC. We have got CPC mediations in CPC, but that is during the judicial process. We have to have mediation provisions in CPC and Authorin Adalat Ain before litigation stage. And to support this position, meaning civil and commercial disputes should be, or banking loan disputes should be resolved through mediation mechanism. Our central bank, meaning Bangladesh Bank, may make rules allowing financial institutions to give better incentives to the defaulting parties in the form of discounting or high level of discounting, who resolve their disputes through mediation before litigation or very early stage of their loan classifications. In summing up, I would like to say in this way, through private mediations and mediations through judicial process, our recovery from NPL would be much more quicker and which can be at very lower pricing compared to our litigation cost. And in this way, the judiciary would be able to concentrate on banking sectors, large and big Authorin suits, and they can be able to manage their cases efficiently. And in this way, our recovery from NPLs would be facilitated through judicial process, as well as mediation in judicial process and by the private mediations. Thank you. Thank you, BIAC and NIAC, for having me here today, and thank you all for hearing me with great patience.
Thank you so much, Ma'am Farzana. Thank you so much for your details and insight presentation. If we could have some questions, we will come with you later on. Now it's turn to call upon Dr. Kumar Sharma Acharya. I would like to say few words for Dr. Acharya. He is Senior Advocate of Supreme Court of Nepal. He holds PhD degree, LLM, MA in different faculties. He is an expert member of Mediation Council, and now he is working as Mediation Ambassador on behalf of Supreme Court of Nepal. With this word, I would like to request Dr. Kumar Sharma Acharya, please proceed.
Thank you, Batrika sir. I would like to welcome all guests from Bangladesh and Nepal. Thank you for you to give this opportunity to address this type of symposium on commercial dispute resolution through mediation. Probably I have allocated 10 minutes for my presentation. I heard about that, so I'm starting
Yes, please go ahead.
probably 10 minutes. Okay, I'll try to finish my presentation within 10 minutes. First, I'm not talking about the arbitration and all the ADR areas, but I especially talk about the Nepalese practice in mediation. And especially how can we benefit from the Singapore Convention on Mediation. My topic will be focused on the Singapore Convention on Mediation. Slightly, I want to share brief history about the arbitration. The Hague Conference that was held 1899 and revised by 1907, that was the departure of arbitration in the world. And United States have done many efforts to institutionalize this arbitration by New York Convention, and we cannot forget the Geneva Protocol of Geneva Convention, as well as Geneva Convention, which was held in 1927. And the ICC and American Court of Arbitration, they have started arbitration in their country, and there was a lack of the enforcement of the arbitration award. And the New York Convention 1958 that gave the opportunity to the world to be the party of the convention and get chance to enforcement the arbitral foreign awards. And United Nations, we all know about the model law. Model law that was adopted in 2002. Model law was especially named by the conciliation process that was named. Like Sri Lanka, they have started the mediation in the name of conciliation. And now they are using the term mediation instead of conciliation. Likewise, UN model law, they have also used the term model law mediation instead of conciliation. That model law was amended in 2018, and the model law was named model law. Previously, it was called model law, and that was renamed by model law on international commercial mediation and international settlement agreement resulting from mediation. They used the term mediation first time in ancestral model law. And we can find American International Bar Association, CS, ICSID, MEGA, WTO, WIPO, NIFRA. These all are using the arbitration tool. And arbitration tool, this was a brief history of the arbitration and New York Convention. That was the great departure. New York Convention was the great departure to implement the arbitration award, which was awarded in the foreign country. And I briefly introduce about arbitration in Nepal. We we have an act that was Arbitration Act 1981, and that Arbitration Act was repealed by Arbitration Act 1999, because this Arbitration Act 1999 was influenced by the New York Convention 1958, and it has the Section 34 statute that that they accepted the rule of New York Convention for the International Arbitration Award. And I would like to share something about the Singapore Convention. You all know Bangladesh and Nepal, we both countries are not the party of the Singapore Convention 8. But in 2018, the Singapore Convention was adopted by UN, United Nations, and in 2019, 7 August, New York, this Singapore Convention has the same provision like New York Convention, and it has 55 signatories, and including China, the great, we can say that US, China, India, Singapore, and many more countries. And convention was into force from 12 September 2020. Till the date, we are not the party. Bangladesh and Nepal, both of us are the party of this convention. This convention, we can ratify, accept or approval of accession. That is the provision of in Article 14.1 of that convention. Singapore Convention especially applies international settlement agreement resulting from mediation. And especially this convention is instrument for the facilitating international trade, effective method of the resolving trade disputes. It is focused to resolve to the trade dispute. And New York Convention and Mediation have a goal. We can say that sustainable development goal, the goal number 16, where the provision of peace, justice, and institution, this is related with this sustainable development goal 16. The convention was open for all, and mediation, we have I have just shared about the Singapore Convention and Mediation, the principles and a few conceptual part of the Singapore Convention on Mediation. Likewise, I would like to share about the development of the mediation in Nepal. Justice Srikant Paudel already told about this, how we departed, and now where are we to implementing the mediation in Nepal. The Asia Foundation, United Nations Development Program, USAID, DFID, DANIDA, McConnell Foundation, UK Aid, and UNHCR, JICA, they are the player. They supported the community mediation and court-related mediation in Nepal. We have community mediation, court-related mediation, and local government mediation. 3 types of mediation in Nepal. And likewise, we are shifting to the commercial mediation. We have mediation center in 35 districts. 35 districts. Each district have at least 30 mediation centers in a district. And we have 77 district courts, 18 high courts, and 1 Supreme Court. And mediation centers are operating, giving the service from these, all the courts. At least 1 mediation center they have in their annex, court annex. And Department of Foreign Employment, they have introduced the mediation, and they have made the roster of the mediators in Nepal, but they have started, but that is not satisfactory. They are not providing the satisfactory mediation service in their India umbrella, but they have started to use the mediation system. FNCCI of Nepal, and we have 752 local bodies where the Local Government Operation Act. Local Government Operation Act has the provision to operate at least 1 mediation center in each ward. We have 6,743 wards in Nepal. So there is a room for providing mediation in all over the Nepal, and the mediation is not only operated by the NGOs or INGOs. This mediation system, mediation service is guaranteed by the Constitution of Nepal. And likewise, we have laws on mediation, Local Government Operation Act, Mediation Act. Mediation Act is known as Umbrella Act. And to facilitate the Mediation Act, we have a mediation regulation that was started from 2012, and we have a mediation council in Nepal, mediation council, and we have Nepalese. We have the commercial mediation. We have a big opportunity to operate the commercial mediation in Nepal. Nepal National Judicial Academy has started, especially Supreme Court of India, Mediation Center, Mediation Committee of the Supreme Court of Nepal is wished to develop the expert mediation especially in 3 areas: commercial sector, family sector, and land and natural resource sector. And we have started the special training we have added this advanced mediation training, and we have started all these to make the expert mediators. And local, likewise, we need to international support to uplift our mediation. UN and UN agencies, Bangladesh and Nepal, we both are in the same condition, and probably Bangladesh, but sure, I'm sure Nepal want to support the international support to uplift the mediation and to expand the mediation service in Nepal, and we need support from the UN and UN agencies, United Nations Commission of International Trade Law and Citral, and Singapore Convention have allocate us to the big room to enforce the mediation other side of Nepal. we can make effective law to implement that document. And we have to motivate Nepal government, Mediation Council, Ministry of Law and Justice, Ministry of Commerce and Industry, Nepal Law Commission, political leaders, parliamentarians to make an effective law related in this field. Government employees, business community, private sector, we have to influence, we have to motivate, because they are not known, they are not known about this Singapore Convention on Mediation. We have to aware them and we have to motivate them to implement this Singapore Convention on Mediation in Nepal. We have to convince Nepal government to be the party of Singapore Convention on Mediation. We have to, awareness activities need to be implemented to awareness activities, and we have to convince all these government stakeholders. We have to enhancement of capacity. Organization mediation, organizations who are working in mediation, we have to enhance their capacity, and mediators who are working in community, court, and local level, we have to enhance their capacity to address the Singapore Convention on Mediation. And we have to convince the stakeholder working in mediation and arbitration in Nepal. So Nepal, we have to join. Nepal has to take steps to ratify the convention and join the coalition of the countries that have already endorsed the convention. Will definitely provide an opportunity for business sector to reduce their stress in settling the dispute that can increase cost of their billings. So Bangladesh and we needs to join our hands. So I would like to, let's join hands together by thank you to providing me this opportunity to address this symposium. Thank you, BIAC, and thank you all the speakers and the organizer who gave me this opportunity to address. Thank you so much.
Thank you so much, Kumar sir. Thank you so much. I'd like to offer our sincere thanks for your detailed insights and especially whole coverage of Singapore Convention. Thank you so much. Now, I would like to request next speaker. He is Barrister Khandokar M.S. Kausar. I would like to share just few words about him. He is Advocate of Supreme Court of Bangladesh. He has specialized in taxation and property law, arbitration and mediation. He is a leading practitioner on anti-dumping and countervailing issue. He is accredited mediator. Then he is associate member of Chartered Institute of Arbitrators and also regional representative of Young Arbitrators Forum of International Chamber of Commerce, Paris. With these words, I would like to request Mr. Kausar. Please, sir.
Thank you very much. Thank you, sir. Good afternoon, everyone, for giving me the chance to speak before that program today. And thanks to BIAC and NIAC, and especially thanks to BIAC for organizing such programs. I would say BIAC is the only fighter in Bangladesh for promoting ADR in Bangladesh. I would especially thanks to CEO of BIAC, Mr. Director of BIAC, and all other members of BIAC, and also thanks to NIAC for participating in that kind of programs. And this would be very helpful probably in terms of trade and relationship between Bangladesh and Nepal. Thank you everyone for giving me the chance. At the very first stage, I would say why mediation is necessary and what is the position of Bangladesh in terms of mediation and everything. Just few words why mediation is necessary. My previous speakers already spoke about that elaborately. So I'm just going to tell that in perspective of Bangladesh, Article 27 of Constitution of Bangladesh, which is saying about the equal protection of law. So I would say that everyone is not getting equal protection of law if there is no alternative methods of resolution of the disputes. If all the disputes are before the courts and if all the disputes are to be resolved by the litigation only, then the problem is that people are not in a equal standing. People will not get the equal position. They are not financially equally stable and equally sound to go to the courts and to solve the problems and to continue the problems for a long period of times. So for the Constitution, referring the Constitution 27 article, I would say that mediation or arbitration, this kind of ADR is very necessary in terms of Bangladesh to give the judgment to the people or to give the access to justice to the people. Then I am going to discuss from another angle the problem with resolving the problem with the litigations people are facing. The people are facing two types of problems with the litigation. One is financial problem, and another, as I said earlier, and another is psychological problem. People are facing psychological problem for long disputes in courts and in litigation in courts and tribunals, everything. One is called cryptogenic harm, which is a psychological harm caused by the litigation process itself. People, whenever people are in litigation, they are faced by that kind of problem, which is called cryptogenic harm. And whenever even everything is going fine in the court for a long period of times, people may face that kind of psychological problem, cryptogenic harm. Another is litigation response syndrome. So if litigation is going on for a long period of times, people are involved in the lawsuits, that people face that kind of problem, litigation response syndrome. Another is forensic stress. People face anticipating and managing the cost of the litigation. People face that kind of problems, that kind of psychological problems. So financial and psychological problems are the main causes for the people to suffer suffer for litigation. This is why mediation, arbitration, and that kind of ADR methods are very necessary for a country. And today we are dealing with mediation especially. And we are dealing with, today's topic is especially confined to mediation in commercial disputes. So what is commercial disputes is, it has been discussed elaborately by my previous speakers, so I am not going to deal with them detailed. I'm just going to speak about one recent commercial dispute which is going on in India, which is called vanilla commercial dispute. This is very interesting dispute which is going on in India. Vanilla commercial dispute. This is a dispute between the 6th richest person in the world and the 1st richest person in the world, among Jeff Bezos, among Mukesh Ambani, and another person, Kishore Biani. this is a commercial dispute among these persons, and Mr. Bezos or Amazon brought an allegation against Ambani, Reliance, and a notice was sent from the Singapore arbitration from Singapore for resolve the dispute in through arbitration. The fact is that why this is important, why I'm discussing that today, because the dispute is a big one for India, but the problem is that this is very strange dispute because Mr. Bezos or Amazon has got some portion from Mr. Biani from his business, personal business, and it was said that he will buy, subsequently he will buy another portion of Mr. Biani, and there was a clause into the contract that nobody other than Amazon would be able to buy the portions from that trade of or that the business of Mr. Biani. And when Mr. Ambani's Reliance for the portion just discussed or disclosed that they are going to buy that portion, then Mr. Bezos sent an notice from Singapore for resolution of the dispute, and there was an interim injunction, and the transaction was stopped. Now the fact is that these are very big players, Amazon, Reliance, big players, but Mr. Biani probably is not a very big player in compared to these players. But if there could be a mediation agreement or Singapore, if Singapore Convention on Mediation is applicable, could be applicable here, then probably the dispute would be resolved very easily and without going through a long arbitration processes, and probably for some party of the claim would be very difficult to go to Singapore and to resolve the disputes through that arbitration proceedings. So this is why in new era of technology and in the trade and commerce era of trade and commerce through COVID-19, big players are coming into the countries, and big investments are coming in. Even in Bangladesh, big investment very soon. Very recently we had a investment summit, and very big investments are coming to Bangladesh. Probably we are thinking that we are hoping that a very big investments are coming to Bangladesh, and before coming these investments to Bangladesh, they will be thinking what are the methods or what are the structures of dispute resolution in Bangladesh, and government of Bangladesh is trying to show that the methods or the structures are very good, and definitely we are developing towards very good structure to resolve this kind of problems, and foreign investments are getting confidence over us to come to Bangladesh. So this is the thing why Bangladesh, why commercial disputes are important to be resolved through mediation, as I said. Now I'm going to deal with specific some Bangladeshi areas about the commercial disputes. My previous speaker told about banking disputes elaborately, so probably I'm not going to deal with that, and I am just going to deal with some real estate issues. In Bangladesh, a good number of, this is a very prosperous area in Bangladesh, real estate. And in real estates, there is a huge problems in Bangladesh. Like people are giving their land for development, and for developers are sometimes they are in breach of contract. Sometimes the landlords are in breach of contracts even. So real estate disputes are in a huge number in Bangladesh. I have gone through a good number of real estate disputes to resolve them, and I had arbitration, mediation, and litigation in this kind of disputes. And in Power of Attorney Act is a very relevant here in real estate. There are many laws, but a Power of Attorney Act is a very relevant factor here. So whenever some landlord intends to give his land to a developer company for the development, and there is a agreement between the landlord and the developer, and these agreements are dealt with Power of Attorney Act, which is Power of Attorney Act 2012 and 2000 Rules 2015. In Power of Attorney Act, there are a number of provisions for resolving the disputes through mediation and ADR, all other ADR, but these are not very properly activated in Bangladesh. Also, there are some fiscal disputes in Bangladesh. I also deal with many of the fiscal disputes, but these are not also very good working in Bangladesh. So I would say Bangladesh is doing very well in terms of ADR and everything. BIAC is trying very hard to promote that kind of things in Bangladesh, but we need to give emphasis on Bangladesh need to give emphasis on passing some act on arbitration or mediation, and if possible, an International Arbitration Act can be passed in Bangladesh as well. And very recently, Bangladesh is going to pass very soon a statute on the Territorial Water and Maritime Zones Amendment Bill 2020, which is going to be act probably very soon. And if this is happened, so maritime disputes will be there, a good number of maritime disputes will be there, and for environment pollution, a good number of steps will be taken by the government. So BIAC can be a good player in resolving such kind of disputes in such kind of disputes in maritime issues. And also, my previous speaker told elaborately about why Bangladesh should sign in Singapore Convention on Mediation. I wrote in a newspaper in Bangladesh about why Bangladesh should sign very briefly, why Bangladesh should sign in Singapore Convention on Mediation. And I again is saying that Bangladesh should sign in Singapore Convention on Mediation because this is very important for the foreign investors to come into Bangladesh. And for many other aspects, we need to sign that. An Arbitration Act, which was proposed in 2018 by the Law Commission of Bangladesh, it needs to be passed. And as I said earlier, international arbitration and a law on international arbitration also can be passed through Bangladesh. So as I said very briefly that for SDG 16, Sustainable Development Goal 16, and for graduation from least developed country, Bangladesh needs to implement this kind of ADR laws and everything. Thank you very much. Thank you, everyone. Thank you for giving me the chance to
Thank you so much. Thank you so much, Mr. Kausar. Thank you so much. Now it's time to request our speaker, Ms. Prakriti Yonjan. I would like to say a few words about Ms. Prakriti. She is an advocate in Kathmandu and she is practicing law in Nepal. She got his bachelor degree from Pune, India, and master degree from UK, from London School of Economy and Political Science. Now she is doing her PhD in University of Hong Kong. With these few words, I would like to request Ms. Prakriti Yonjan, please.
Thank you, Matika sir, for the introduction. I've asked Shreya to help me with the PowerPoint presentation today. So I'm honored to be here and speak about commercial mediation for investment disputes in Nepal with such an eminent panel, particularly Honorable Justice Shrikant Paudel and Dr. Kumar Sharma, as well as my counterparts from Bangladesh. So today's presentation is going to be focused on investment disputes in particular. Now, when we're talking about disputes, we often share, if you could go on to the next slide, please. So when we're talking about disputes, we often talk about how dispute resolution is a remedy to resolve disputes. but it also has other advantages, such as risk prevention, sustainability, protection of interests and value addition, deal making between parties, growth of business. If you remember the doing business reports by the World Bank, which is, I think, recently scrapped, dispute resolution is seen as one of the indicators for doing business in a particular country, particularly independent, efficient, and fair dispute resolution was seen as one of the indicators. Dispute resolution also results in saving time and cost efficiency if they are effective. And so going on to the next slide, the suitability of mediation for investment disputes. Now, investment disputes may occur between state entity, or regional economic integration organization and national of another state or a local entity. Now, here I've listed some of the points as to why mediation may be suitable for investment disputes, particularly that it's a voluntary process based on party autonomy. Mediation in itself is efficient and cost-effective. It avoids a win-lose outcome. So both parties have a win-win outcome. It's not as formal as, for example, court or arbitration, and the rules are not as complex. Thanks, Shreya. So here I've discussed some of the international legislation on mediation, which I think Kumar sir has already dealt with. So I'm going to skip this. And here I'm going to talk about the background of why it's pertinent to Nepal. So in Nepal, we have something called the periodic plan, 5-year periodic plan. And as per the 15th periodic plan in which we are running today, Nepal intends to be an upper middle income country by 2030. Now, Mr. Rumi Ali has already mentioned about the UN General Assembly resolution, which endorsed the proposal for Nepal, Laos, and Bangladesh to be a middle income developing nation. For this, FDI is important. Now, FDI has seen a fall because of the pandemic, 35% as mentioned in UNCTAD's World Investment Report. Now, looking at Nepal's own history in investment, you can see that over the last decade, can we go on to the next slide, please? Right. Over the last decade, 52.24% has materialized. In the last year alone, 11.44 billion has been approved. Now the IBN intends to approve investment of at least USD 10 billion. So how do we attract investment? I think for both Nepal and Bangladesh, this is an important question. And this is where the role of an efficient method of dispute resolution comes in. So the data I've shared today is from the Investment Board of Nepal and the Central Bank of Nepal. In the next slide, I will be talking about the investment procedure of Nepal and give you an overview of that as well. Can we move? Right. So the major agreement and treaties related to trade and investment of Nepal are listed here. We have something called the Bilateral Investment Promotion and Protection Agreement with Finland, France, Germany, Mauritius, and UK. We have the double taxation avoidance agreements with 11 countries, of which Bangladesh is one of them. We also have Treaty of Trade and Transit with India and Transit and Transport Agreement with China. Now with Bangladesh alone, our history is quite, goes back quite a while. We have the Joint Economic Commission as of 1978, the Foreign Office Consultation Mechanism, I think of 2017, and recently we have a Facilitation Joint Technical Committee, of which hydropower has been highlighted. So there are continuous engagement between the two countries, and it remains to be seen how we can explore mediation in these treaties and agreements. Talking about the earlier slide, I spoke about the bilateral investment promotion agreement between Nepal and, for example, the UK. In this, for example, the disputes are referred to International Convention on Settlement of Investment Disputes, or arbitration. Now, looking at the convention, it talks about mutual consultation and then arbitration. Similarly, in the double tax avoidance agreements, there's a scope for joint commission. So within these treaties as well, there is a need to incorporate mediation. So coming back to investments, there are two kinds of investments. One is, or you could say, private investment can be domestic or foreign. Domestic directed investment also plays a role in our economy, and FDI, of course. So for both kinds of investment, dispute resolution is necessary. And here is the investment process of Nepal. Now, so initially there's a consultation, there's an investment application by the investor, there's an investment approval. There are two main bodies that do investment. One is the Investment Board of Nepal and the other is the Department of Industries. All projects above US $60 million are with the Investment Board of Nepal. So then there's acquiring of company and company registration, there's tax, there's central bank clearance, permits, approval, registration and licensing, negotiation and agreements, and additional services. Now in the next slide, I've listed, and I've got this chart from ICSID's background paper on investment mediation itself, which is developing a new set of rules. Now in that, you can see, for example, where mediation can play a role. So for example, there's a disagreement, there's a problem, there's a grievance, and there's a dispute, and then it turns into a legal dispute. Now, going back to the earlier slide, there are different processes in which dispute may arise, and that may be mediated. So with these two slides, I think in ICSID, it's referred to as a cooling off period. So it can be before arbitration, but it can also be during, which again is a mixed method. So the relevant legislations regarding investment in Nepal are the ones that mention ADR mechanism. And by that, I mean conciliation and then arbitration is Foreign Investment Technology and Transfer Act, the Public-Private Partnership Investment Act, and the Special Economic Zone Act. The other acts which do not mention are mentioned here as well. And here in the local legislation as well, there is scope for mediation to be inserted. Now, the relevant protection for investment in terms of the Foreign Investment Technology and Transfer Act are mentioned in the next slide. And in that, I've mentioned, for example, the protection and promotion of investments, national treaty and most favored nation, compensation for losses, expropriation, repatriation of investment. These are protections afforded as a member of WTO as well, which both Bangladesh and Nepal are a part of. And these are instances where investment disputes arise and where mediation may be needed. To conclude, when should the reference to mediation be? So as I mentioned earlier, it can be at international treaties and investment agreements. We also have regional agreements with both Nepal and Bangladesh are a part of. SAFTA, BIMSTEC, BBIN are a few examples. And if those mediation agreements are not included in those treaties, we have instances of local legislation, of which I gave a few examples. If not in the local legislation, there's also a possibility to have it in ad hoc agreements. Now, whether mediation should be voluntary undertaking or by parties giving an undertaking or mandatory, I think further study is required into this before recommending what is most suitable for commercial mediation. So dispute resolution clause, particularly mediation, needs to be preemptive, it preserves option, it retains controls, and it needs to obligate participation for it to be effective. Talking about institutional and ad hoc processes, when state elements get involved, there's a sort of hesitancy, particularly in investment disputes, for them to settle. Talking about Nepal particularly, there's a hesitancy because there might be cases of corruption where parties feel that they don't have the authority, they might as well fight it out in court. So that is where the role of institutions like BIAC and NIAC come in, and states show preferences for institutions more than ad hoc processes. I've already talked about the possibility of mixed processes, MED-AB, and so that's why I think there's a sort of hesitancy on states and even the commercial community. So we need to raise awareness by engaging relevant stakeholders. In Nepal, there's, for example, I already talked about Investment Board of Nepal and Department of Industries, but also a Federation of Nepal Chambers of Commerce and, for example, Confederation of Nepal Industries. So engaging both the public and the private sector and changing their mindset about mediation is important. So if you compare to international models, for example, the efficiency of Singapore International Mediation Center is at 70%. So how can we make our mediation processes effective as well? I think we need to learn from other examples. And I talk about the pre-action protocols in the UK, which was introduced after the Wolf reforms in 1990. So in the UK, they have certain costs and consequences if parties do not refer to mediation. So this is again at the level of legislation, and this ensures that parties not only do a tick box and say yes we have tried, but actually try to resolve the dispute through ADR. There's also a need to streamline the process for commercial products. So that's it from my end today. I'd like to thank BIAC and NIAC for this opportunity, and I look forward to the question answer round. Thank you.
Thank you so much, Prakriti. Thank you so much for your presentation with latest data. Thank you so much. Now we are nearly to the end of this program. We have one speaker to take his role. First of all, I want to call upon Shaharir Sadat. Last speaker he is. About him, I want to say just few words. He is advocate of Supreme Court of Bangladesh. He is an accredited mediator and a master trainer on mediation. Currently, he is working as director, academic and legal empowerment of Center for Peace and Justice, BRAC, University Dhaka. He works for London College of Legal Studies, South, as a faculty member. He is panel member of Bangladesh International Arbitration Centre. With this word, I would like to request Mr. Sadat, please.
Thank you. Thank you, Mr. Moderator, Mr. Matrika Nirola. Dear audience, I'd like to speak about, I'd like to take a step backward here today and want to talk a little bit about the overall lay of the land of mediation in Bangladesh. Now, one point I keep on repeating to all the forums, that ADR is something which is not new to Bangladesh or to the subcontinent. I'm sure countries like Nepal, Bangladesh have always had informal dispute resolution inbuilt in our society, where we used to go to our elders. One thing that has always been lacking is the institutional framework of ADR, and I think the initiative by the business bodies and forming an organization like BIAC is a big step towards institutionalization of ADR and mediation in Bangladesh. And that's a very welcome change in terms of dispute resolution in Bangladesh. Now, if we want to look at the kind of a bigger picture of where we stand, the picture in terms of comparison globally is not very pretty, I must say. Now, if we look at the ease of business index, we were 168 out of 190, although we went up 8 notches, but it's not good enough. And one of the reasons is the lack of enforceability of commercial contracts. and that's one deterrence for investment. And if we look at the latest in 2021 global rule of law index, we stand 124. We went one step up, but still I think we are consistently failing there. In terms of global ranking in dispute resolution of civil disputes, we rank 119 out of 128, and 5th out of 6th within the regional space. So I would say that looking at the bigger picture, we are not really doing well, and that is where I think this kind of discussion on dispute resolution and mediation is so important. Now, where are we failing? Let's talk about some of the positives that has happened. We have in Bangladesh, we have enacted laws about ADR, about mediation, where government has been tirelessly trying to bring in ADR as part of the dispute resolution process. But I also see that there is a problem there. My colleagues who are practitioners would recognize that our ADR practice is too court-centric. If you look at the laws are not saying that go for mediation or arbitration before you come to the court, because that's the whole purpose of ADR, that ADR should come first and court should be used as the last resort. But in our legislations, we see that people are being sent for ADR, for arbitration, or for mediation after they come to the court. I think this also defeats the overall purpose of ADR, and this is where I think we need to rethink about our strategy, rethink about the future. Now, I also feel that within our legal system, there must be a change in culture of doing business, in culture of litigation. And that is where we need to rethink, we need to incorporate ADR provision in standard forms of contract. We need to prepare our lawyers, our future lawyers, understanding ADR better. Therefore, having ADR studies in our legal education is a must. That would prepare our future generation of lawyers, and that would probably be more effective in terms of changing the overall culture of litigation in our country. So I think with that, I would like to go back to appreciate what my previous speaker from Nepal, Ms. Prakriti, actually mentioned. She mentioned about pre-action protocol in the UK. I think that's a very good suggestion to have in countries like Bangladesh and Nepal. And also, I'd like to reiterate the fact that the Singapore Convention should be ratified by Bangladesh, because as Mr. Rumi Ali in his inaugural speech, he mentioned that there are a lot of disputes that are crossing the boundaries of the country. Those have got international jurisdiction, multiple jurisdictions. And in that point of view, I think Bangladesh should also go ahead to sign the Singapore Convention. With this, I would like to hand over the microphone to the moderator. Thank you, ladies and gentlemen.
Thank you so much, sir. Thank you so much for your short and sweet presentation. Thank you so much. Indeed, we are very closer to the end of this event. Finally, I would like to request our chairperson of Nepal International ADR Centers, Mr. Dr. Mukti Rizal. Dr. Mukti Rizal is a lawyer and a multi-stakeholder disputes resolution and mediation expert in Nepal. He is PhD holder on local governance, mediation, and dispute resolution from Tribhuvan University, which is big and older university in Nepal. Mr. Rizal has authored several books on mediation. One of his recent publication is Mediation and Dispute Resolution in Nepal, Perspectives and Practice, which is published by NIAC. With this introduction, it is my turn to go out, even though I would like to say just few things. And finally, I'm so sorry with those friends if I could not pronounce your name properly. Also sorry for taking some more time as estimated by our organizer. I think NIAC and BIAC need to go longer and with so many partnership and collaborative works. With this word, I would like to call upon Dr. Mukti Rizal, please.
Thank you,
Sorry,
Matrika.
Dr. Rizal, before you speak, I would like to request Mr. Azad to introduce BIAC chairperson after completion of Dr. Mukti Rizal's presentation. Please.
Thank you. Thank you, Matrika ji, for your kind of inflated introduction. Thank you again. On behalf of Nepal International ADR Center, I convey my respect and appreciation to Bangladesh International Arbitration Centre and esteemed Bangladeshi colleagues, friends and participants for taking initiative to forge collaboration with the Nepalese counterpart, NIAC, and putting in all efforts to make this webinar a success. Today, I am reminded of the time more than 20 years ago when I was part of the lawyers team that visited Bangladesh, where the team was received with warmth, cordiality, and hospitality. The then senior advocate of the Supreme Court of Nepal, who later became one of the highly admired and respected Chief Justices, Mr. Anupras Sharma, was also in that team. Our interaction with the Bangladeshi jurists, lawyers, and advocates in Khulna, among others, is deeply imprinted in my memory. Today, NIAC and BIAC have come together to initiate a new chapter of our relationship, to share and exchange our knowledge, insights, and experiences, especially in the area of alternative dispute resolution, as arbitration and mediation. I proved to be appropriate and effective mechanism to resolve both commercial and non-commercial disputes in our part of the world. Without delving into the matter further, I thank friends and colleagues from both the organizations who have contributed significantly in bringing us together into this webinar platform. My deep respect and admiration goes to Chief Executive Officer, BIAC, Mr. Mohammad Ali Rumi, for his welcome note tinged with erudition and insightful eloquence. I also thank NIAC Managing Director and Moderator of this event, Matrika ji, for his excellent facilitation of the program. Similarly, I am thankful to Director of BIAC, Mr. Akmal Hussain Azad, BIAC Counsel Rubaiya Ahsan Karishma, and NIAC Executive Officer Shreya Nepal for the excellent carrying out of the respective roles. In this webinar, we have heard from 6 learned, knowledgeable, and experienced speakers: Justice Srikant Paudel, Barrister Farzana Ahmad, Dr. Kumar Sharma Acharya, Barrister Khondakar Kausar, Prakriti Yonjan, Mr. Shariat Sadat. Each speaker has shared profound knowledge and the experiences in their respective areas of expertise. I extend my gratitude to all of them. I would like to offer my thanks to learned discussants and participants who made this event a thumping success. Finally, I am confident our relations and mutual collaboration shall be strengthened in the days to come. Yes, this will benefit the two countries enjoying state-to-state relation and people-to-people friendship and cordiality. Looking ahead with a sense of optimism and hope, permit me to conclude this webinar proceedings. Namaskar. Wish you happy upcoming New Year 2022. Thank you again.
Thank you so much, Mukti sir, Dr. Mukti Rizal. Now, I would like to request Mr. Azad to take your lead. Please,
Thank
sir.
you. Thank you, Nidaulaji, and thanks, respected chairperson of NIAC, for blessing this occasion. I would now request our chairman, Mr. Mahbubur Rahman, to say a few words. Mr. Rahman is the current and founding chairman of Bangladesh International Arbitration Centre and the BIAC board. An eminent businessman of the country, he is also the president of International Chamber of Commerce Bangladesh, ICCB. He is the only arbitrator from Bangladesh at the China International Economic and Trade Arbitration Commission, CITAC. Mr. Rahman is the chairman and CEO of ETBL Holdings Limited and chairman of the International Publications Limited, publishers of the Daily Financial Express. He hosted several international business and economic events in Dhaka, attended by heads of governments, and led many trade and investment delegations to a number of overseas destinations, including leading a few business delegations as entourages of the President and the Prime Minister of Bangladesh. Among the 150 high-impact leaders in business and social enterprise from Africa, Asia, Latin America, and Middle East, Mr. Rahman has been interviewed under the Creating Emerging Market Project, CEMP, at Harvard Business School, USA in October 2020. Over to sir.
Thank you. Thank you, Akmal. And good afternoon to my friends from Nepal. My particular association with Nepal-based banks dates back from the early 80s. So it is almost 40 years that we have been having our cooperation in the business and economic affairs, and more in the cultural as well, from those days. However, and our cooperation with the Nepalese business, as well as with the leaders in the social sector, I would like to say thank you once again to the Nepal International ADR Center for joining BIAC to hold this webinar in this pandemic situation. The BIAC has been trying its best from the day one after this COVID affected this entire world, so that we do not lose touch with the people that we need. Here in Bangladesh, you might have heard that our judicial system has also introduced that under a virtual system, the court proceedings may also continue, and accordingly, and a law has been enacted in order to provide support that virtual witness and virtual presentation of arguments in the case is hereby accepted as legal. And in the business also as well, we have been negotiating through the webinars and also through virtual position. And here in this case, we are not sitting quiet because due to the COVID, we are not being able to do so. Only thing is this, that whether the what is called force majeure clause should be also effective should be also applicable for this COVID-19. This has not been decided as yet by the disputants or by the authorities concerned, including our United Nations arbitral system, but we will continue to work together even with this difficult time and look forward to cooperate each other in the situation that is ahead. Fortunately, in Nepal and also in Bangladesh, the COVID situation is coming to a more tolerable range, but you never know that one after another there are new wave and a new variant comes in. Now the African variant is coming. Nevertheless, we will continue our trial and we will continue our efforts in bringing the world together under this digital system, and the Bangladesh International Arbitration Centre, as well as Nepal ADR Center, we will continue to our efforts in proceeding our economy and the society at large to bring about change in the overall system in the world trade, as well as in practicing law and judicial system. Thank you very much, our friends from Nepal, and more particularly to the Chief Executive of and who is also the moderator, Matrika Prasad Nidaula, Managing Director of NIAC, for holding and moderating this session and cooperating with the Bangladesh International Arbitration Centre. And I must also mention very clearly that without our Chief Executive, Muhammad Rumi Ali, I am almost nowhere. He has been taking the charge and taking ahead, irrespective of the situation in the country due to the pandemic and also in our other situation. And we are trying our best to go forward. From all these points of view, I would like to say once again, friends from Nepal and those speakers from Bangladesh as well as from Nepal, they have been very, very helpful and have presented their practical knowledge in this case. And let us continue our cooperation in the time and years to come. Thank you very much indeed.
Thank you so much, sir. Thank you so much for your kind presentation, kind words. Azaji, I would like to request your IT team, if we may need to take photo, please request all to open their camera now.
Thank you, Riyaji. We have did that part. Now our admin will close the session formally.
Oh, thank you. Anilji, thank you so much.
Thank you so much, ladies and gentlemen. This has been a wonderful webinar. Our friends from Nepal, all our guests, all our speakers from Bangladesh, everyone, thank you so much for giving us your time. And we have received quite a few recommendations, good recommendations, and we do look forward to having you with us in our next events. This marks the end of the webinar for today. We will see you next time. Do join us. Thank you so much.
Thank you.